Bismillahirrahmanirrahim. Thank you, Your Excellencies, for joining the panel in this event on a very important issue in Myanmar that has reached a global scale. And thank you, the audience, for tuning in. Today, we have a great panel that will address the Rohingya crisis from various perspectives. In the panel, we have five distinguished speakers. First, Honorable Minister Dora Jallow from Gambia, representing Attorney General, representing Solicitor General representing Minister Dora Jallow of the Republic of Gambia. Our Excellency Ambassador Rabah Fatima, Permanent Representative of Bangladesh to the United Nations, Mr. Arsalan Suleiman, Counsel from Foley Hoek Law Firm in Washington, Dr. Hassan Abedin, former Director of Muslim Minority and Community Department in OIC, and Dr. Gregory Stanton, the founding president and chairman of Genocide Watch in Washington. Your Excellencies and distinguished guests, this coming Friday, the 23rd of January, marks the first anniversary of the ruling by the ICJ on the provisional measures that was ordered to Myanmar. This is a major step with great significance. As a result of the ruling, there are evidently some activities by Myanmar government on the ground in Arakan, but by no means they are adequate, at least at this point. Yes, we understand that everything has to start from something. Now that things have started to move on the ground, as well as in the diplomatic front, we are hopeful that Myanmar government will step up addressing the issues on the ground, as well as expediting the repatriation of Rohingya refugees from camps in Bangladesh to their original homes in Rakhine State, Arakan, Myanmar. The trilateral meeting between China, Bangladesh, and Myanmar on the 19th this week was encouraging according to reports. In this process, allowing Rohingya refugees to return to their original homes, I stress original homes in the native Arakan, in their villages, and their short and long-term security issues in Myanmar are pivotal in solving Rohingya crisis. From all the perspectives, it is clear that the case at the ICJ is instrumental in finding a solution to the crisis on the ground, starting from the implementation of the provisional measures. With that, I would like to introduce Solicitor General of Gambia, representing Honorable Minister Dora Jallow to deliver the keynote speech. I have here the bio introduction of, although Solicitor General speaking, I will cover a little bit about the Honorable Minister Dora Jallow. I was just told earlier, a minute ago, that Honorable Minister has meeting with the President. So that's why Solicitor General, His Excellency, is replacing him. So I did not have his detailed bio because he just joined in. So forgive me for not available, but I do want to cover Honorable Minister Dora Jallow a little bit. Hopefully, inshallah, in the future, he will be able to join. Or he may be joining today when he is done with the meeting with the President. Honorable Dora Jallow is currently the Attorney General and Minister of Justice of the Republic of Gambia. His Honor received his LLB law degree from University of the Gambia, BL in Barrister at Law from Gambia Law School, and Master of Law, ML, from University of Essex. Gambia is the chair of the ad hoc committee of the OIC, and it is leading the Rohingya genocide case at the ICJ. There are a lot more about the minister, but due to the time constraint, I will straight go to Solicitor General on behalf of Honorable Minister. Welcome, Your Excellency. Let me just say this. the Rohingya people and the international community is looking up to the leadership in Gambia, your team, Honorable Minister and Solicitor General, your team, in the ICJ court case, the Gambia versus Myanmar. Would you give the audience an overview of the case and the prospect of the final determination of the Rohingya genocide case at the ICJ in your keynote speech? You're welcome. Thank you very much.
Thank you very much, Dr. Wakar Uddin. Your Excellencies, distinguished members of the panel, distinguished ladies and gentlemen. Let me first extend the apologies of the Honorable Minister Dauda Jallow for not being able to be present with you at the forum. He is presently on a cabinet meeting that started this morning and is still ongoing. Thursdays are usually cabinet meetings in the Gambia. So he's still engaged in office at cabinet level and has requested me to read his statement on his behalf. Distinguished ladies and gentlemen, it was on the 10th day of December, 1948, that the world adopted through the General Assembly of the United Nations, the Universal Declaration of Human Rights. The declaration has permeated and served as an inspiring source for virtually all human rights instruments we know today. The declaration proclaims under its first article that all human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood. It recognizes under Article 3 that everyone has the right to life, liberty, and the security of person. And under Article 5, that no one shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment. The declaration serves as a check on authoritarian rule and massive abuses and violations of human rights that were prevalent and still continues to prevail in the world. It is imperative that we reflect on the genesis and antecedents of events leading to the Universal Declaration of Human Rights. The scourge of the Second World War and the Holocaust, leaving in its wake untold horrendous deaths and sufferings unprecedented in history, has led us to declare never again in our history would we allow the recurrence of such barbaric and horrific incidents to happen again. The influence of the declaration in serving as a powerful source to fight oppression, racism, and to ensure accountability and justice was felt all over the world. Ladies and gentlemen, it was a blemish on our collective conscience that 46 years after the declaration, the world witnessed the genocide in Rwanda with over 1 million people killed in just 100 days, and the genocide in Bosnia with over 8,000 men and boys killed simply for belonging to another ethnic group or religion. 25 years after the genocide in Rwanda, we are today witnessing the brutal and barbaric acts of the genocide of the Myanmar, their homes and places of worship, destruction of their homes and properties, all in an attempt to exterminate them. Exterminate them for the simple reason that they were born to a different race and a different religion. We should bear in mind that human rights are universal in nature and belong to the people in the world everywhere. They are inherent to all human beings everywhere in the world. As one time stated by a famous Secretary General of the Commonwealth, and I quote, "The dignity of man is everywhere affronted when the human personality is anywhere degraded." Quotations closed. It is in this light that the conscience of the world should be awakened to what is happening in the Rohingya in Myanmar, which is nothing short of genocide. On 11th November 2019, the Gambia filed a case against Myanmar at the International Court of Justice, accusing Myanmar of genocide against its Rohingya Muslim minority in the case of the application of the Convention on the Prevention and Punishment of the Crime of Genocide. Both the Gambia and Myanmar are signatories to the 1948 Genocide Convention, which compels all members to prevent and punish the crime of genocide. The case was brought with the support of the Organization of Islamic Cooperation, which had tasked the Gambia to look into how Myanmar can be brought to justice following the Gambia's initiative to seek justice for the Rohingya. On the 23rd of January, a unanimous decision by the International Court of Justice in The Hague ordering provisional measures to prevent further acts of genocide from occurring in Myanmar was made by the court. The court's decision was historic and celebrated by human rights defenders all over the world, drawing global attention and action on the Rohingya crisis. Myanmar was ordered to report to the court 4 months after the ruling and every 6 months subsequently on its compliance with the court's orders. As we commemorate today the anniversary of the historic ruling by the International Court of Justice, the question surely arises as to what has been the impact on the lives of the Rohingya people and the crisis in general. I must say that for the first time, Myanmar is being made to account for the atrocities. It has been compelled by the International Court to report on its compliance with the court's orders to ensure that it puts a stop to the genocide. Ladies and gentlemen, it is very heartwarming to know that countries such as the Netherlands and Canada have rallied alongside the Gambia to pursue the case at the court. The Commonwealth Secretariat has also taken serious note and intends to employ members to support the Gambia. It is expected that more and more countries would join the sacred and noble crusade to ensure lasting justice for the Rohingya. Other countries have immediately after the ruling imposed targeted sanctions against senior military officials in Myanmar. It is, however, our opinion that more needs to be done by the international community, especially to pave the way and facilitate the return of nearly over 1 million refugees back to Myanmar. The reality on the ground is that the situation in Myanmar is still critical, and that Myanmar is not preparing the grounds for the return of the Rohingya. And even those, the conditions of the Myanmar in Rakhine state has even worsened. Distinguished ladies and gentlemen, this view is confirmed by international observers and organizations. The International Crisis Group has reported that the Rohingya who remain in Rakhine state have seen no meaningful improvement in their living conditions. They face apartheid-like bans on access to hospitals, schools are mostly segregated, and freedom of movement remains curtailed. Restrictions on humanitarian access further compounds the apply. Amnesty International has also concluded the same, that conditions have not changed and the Rohingya in Rakhine states are still in dire conditions. Amnesty International has even observed that the Rohingyas are still denied their rights to nationality, freedom of movement, and access to justice and services. The same situation is confirmed by Human Rights Watch. Ladies and gentlemen, it is our firm belief that more international pressure needs to bear on Myanmar to comply with the court's orders and to ensure that the road for the Rohingyas to return to Myanmar, to run back to their homes, is adequately prepared and grounds are conducive for them to do so. Ladies and gentlemen, whilst I wish you all a very reflective commemoration of this event, I want to assure you that the Gambia remains committed to its cause to ensure lasting justice for the Rohingya. The world has been able to fight slavery. The world has been able to end apartheid. The world has been able to end colonization in its worst forms and other dehumanization. The world will certainly be able to end the genocide of the Rohingya. On this note, I want to thank you for your kind attention and to wish you all a successful deliberation. I thank you all.
Thank you very much, Your Excellency, for a very touching speech, and we hope and pray that we will find a solution with your efforts, leading efforts by Gambia. If Your Excellency, you could stick around a little longer during the session, we'll have a Q&A session. If you are available during the session, that will be great. There will be some questions for you. Thank you very much, Your Excellency. Now, I will move on to second speaker. Our second speaker is Ambassador Rabab Fatima. Ambassador Rabab Fatima, a little introduction about Ambassador Rabab Fatima. Ambassador Fatima is the permanent representative of Bangladesh to the United Nations in New York. Prior to the United Nations, Ambassador Fatima was Bangladesh ambassador to Japan. Ambassador Fatima is a career diplomat and joined the Bangladesh Foreign Ministry in 1989, and she has served in various Bangladesh missions in a number of countries. In the Ministry of Foreign Affairs, Ambassador Fatima has served in various positions. She was instrumental in generating awareness of the Rohingya cause, Rohingya issue, and her passionate support for the Rohingya cause. The event that Bangladesh Mission organized last year here in New York is a testimony to that, her efforts, her success. In addition to that, this year, the resolution on Myanmar was a great success. Despite the COVID pandemic, all the restrictions, effort by the Bangladesh Mission was highly successful to bring in qualitative and quantitative changes in the resolution. She has also been engaging with all stakeholders, including the ambassadors, UN mechanisms, civic societies, and diaspora to keep the agenda alive in the United Nations in New York. With that, I would like to introduce Her Excellency Ambassador Rabab Fatima. The floor is yours, Your Ambassador, Your Excellency.
Thank you. Thank you, Dr. Wakaruddin, for that very undeserving long introduction. Thank you very much. Distinguished members of the panel, excellencies, distinguished guests, dear friends, salam alaikum, and a very good morning to you all. I thank the Arakan Rohingya Council for organizing today's commemorative event. I'm very happy to join today's distinguished panel to share a few thoughts. Mr. Solicitor General, thank you for reiterating Gambia's and Minister Jalau's strong continued leadership and support for the cause of the Rohingyas. 23rd of January is an important day for the Rohingya and also for the international justice system. This day last year, the International Court of Justice, for the first time in the history, recognized the Rohingya as a protected community and presented some glimmer of hope that could lead to a dignified life for them in Myanmar. The ruling of the court was also a reminder that such exclusionary policies that forces over 1 million people from their homes can never be condoned or overlooked by the international justice system. And I wish to thank in particular Minister Jalao and all others who have supported this process to ensure justice and accountability. Bangladesh as an immediate neighbor has been a recurring victim of Myanmar's discriminatory policies. We have been sheltering the forcibly displaced Rohingya for over 4 decades now. Although in earlier occasions, such arrivals were resolved through repatriation, however, it is clear now those were not sustainable. The same Rohingya individuals or families have returned to Bangladesh seeking shelter and protection over and over again. And this is so because the situation for them continued to worsen with each passing year. And the carnage, the brutality that the world witnessed in 2017 is testimony to that. Distinguished guests, there cannot be any durable solution to the Rohingya crisis without addressing the problems that continue to exist in Myanmar. Rohingyas will never have a safe and sustainable future in Myanmar unless and until they're embraced as equal members of the Myanmar society and provided with the rights, dignity, and opportunities that they are entitled to as the rightful citizens of their country. We believe that the ruling of the International Court of Justice ordering provisional measures is an important step towards that direction. We are confident that the compliance of the court's ruling in letter and spirit by Myanmar would eventually lead to an environment that is conducive for the return of the displaced Rohingyas from Bangladesh and to live in peace and safety in their homeland. Thus, what remains most important is the compliance of the provisional order at this point of time. And this would require a constant monitoring and international supervision. Without that, the implementation of the ICJ ruling would not bring about any change that we are warranting in Myanmar. It is regrettable that Myanmar continues to deny access to the UN mechanisms and other independent observers. Even the Office of the Special Envoy of the Secretary General and other UN agencies have very limited presence in Myanmar. In such a situation, objective assessment of compliance remains difficult. We understand that Myanmar is submitting its periodic compliance reports to the court. We are also encouraged by the recent decision of the ICJ to form ad hoc committees composed of 3 judges to assist the court in monitoring the implementation of its provisional measures. And we believe such an ad hoc committee would be critical in ensuring realization of the provisional order issued against Myanmar. Distinguished guests, dear colleagues, let me now briefly turn to the current situation, especially the situation on the ground in Bangladesh. As we have all seen, the much awaited general election of Myanmar was held in November last year. Unfortunately, the election meant little to the Rohingyas. They were not allowed to participate in the elections, and they continue to remain disenfranchised. The security situation remains volatile, with incidents of hate speech against the Rohingya Muslims rising. No demonstrable progress is visible in amending the discriminatory laws and policies in Myanmar that makes ethnic minorities susceptible to violence and persecution. Access to humanitarian actors and other independent observers remain severely restricted. There is no progress at all regarding the repatriation of the Rohingyas in Bangladesh. As per the bilateral agreement of return, Bangladesh has submitted family-wise data of 830,000 Rohingyas to the Myanmar authorities, out of which Myanmar has responded with respect to 42,000 only. And of this 42,000, only around 27,000 have been cleared as residents of Myanmar. And even of the declared ones, most of the families have been split, which in essence means they would never volunteer to return. So it is a non-starter. Earlier this week, we had a trilateral meeting with Myanmar and China on the implementation of the Rohingya repatriation agreements. During the meeting, we have proposed to begin village-wise repatriation, and we are waiting for Myanmar's response to that. We have also proposed to include other partners in the process. Agreement has also been made to have joint working group meetings between the 2 countries soon. As you can see, Bangladesh remains committed to any process or efforts that would lead to a resolution of this crisis. However, it goes without saying that no process or initiative would have its impact unless and until the situation on the ground changes. For that to happen, Bangladesh continues to call for the international community's custodianship to the bilateral process and also sustained advocacy by all stakeholders to address the root causes in Myanmar, and very importantly, ensuring accountability for the crimes committed against them. In this regard, I would like to refer to, and Dr. Wakaruddin, you also mentioned a little bit earlier, I would like to refer to the UNGA resolution that was adopted last month. This year's resolution, as you said, actually includes qualitative and quantitative changes and marks an important step forward. The large number of co-sponsors and votes in support was also very reassuring to us. The issue of accountability featured quite strongly in the resolution, not only in respect of crimes committed against the Rohingyas, but also in respect of the international community's engagement in Myanmar, particularly those involved in trade and investment in Myanmar, as they will be required to strictly adhere to the guiding principles of business and human rights. That is what we have asked for in the resolution. The resolution has also extended the mandates of the UN mechanisms in Myanmar, that is that of the Special Rapporteur, the Special Envoy, the Secretary General, and the Independent Investigative Mechanism on Myanmar. Regrettably, we are yet to see any positive indication on the part of Myanmar to engage with these mechanisms meaningfully. and the international community's continued advocacy would be critical to ensure that. To conclude, distinguished panelists, dear colleagues, I would like to stress that the importance of consistent and coordinated engagement of the international community, including of the diaspora organizations, cannot be overemphasized. It is a culmination of our collective efforts that today we have the International Court of Justice, hearing the stories of the sufferings of the Rohingya and calling Myanmar to protect this population to the threats of genocide. We need to keep this agenda very high in every possible discourse until the Rohingya people are assured of their rightful place in Myanmar, where they lived for centuries. I thank you once again for your continued support and engagement, and I would like to especially thank the Arakan Rohingya Council, Dr. Wakaruddin and others who have been dedicated to see to it that their people get their rights and dignity in their own country. I thank you all for this opportunity to share a few thoughts. Thank you very much.
Thank you, Your Excellency, for making yourself available to speak in this event. And I had 3 questions for you, and I just noticed that all the questions we had for you have been answered in your speech. So that's great. So good luck in our meeting at the UN. Inshallah, we will catch up again some other time. Assalamu alaikum. With that, I'm going to move to our 3rd speaker, Attorney Arsalan Suleiman. Arsalan Suleiman is a counsel at the law firm Foley Hoag LLP in Washington. He is a key member of the legal team representing the Gambia in its genocide case against Myanmar at ICJ. He is also, actually, let me say this before, I have known Arsalan, Attorney Arsalan, for a long time, many years, probably 8-10 years. We met in the State Department, and Brother Arsalan Suleiman was the former acting U.S. Special Envoy to the OIC, Organization of Islamic Cooperation. So when I used to go to State Department, we always met there. So I knew Arsalan for a long time in Washington. So, but due to time constraint, I'm going to keep it short, and I will ask the introduction. I think it's sufficient at this point. I will ask Counsel Suleiman to shed some light to the audience on the legal significance of the case as a whole, a genocide determination, as we all know, and the significance of the rationale of the 4 provisional measures that we have asked the court, and then some insights to Genocide Convention, with regard to some insights to Genocide Convention, and relevance to Article 2 and Article 3 and others to violations against Rohingya by government of Myanmar on the ground in Arakan state. With that, Attorney Arsalan, Mr. Arsalan, floor is yours.
Thank you for that very generous introduction, Dr. Wakar. And it's a pleasure to be here for this panel hosted by the Arakan Rohingya Union. And my greetings and thanks to all of the distinguished fellow panel members. Really enjoyed the presentation by His Excellency, the Solicitor General, Mr. Hussein Tomasi, as well as by Her Excellency, the Ambassador Fatima from Bangladesh. Both really excellent overviews of where things stand right now with many respects to the case. And for Solicitor General Tomasi's presentation, a bit of insight into why the Gambia felt motivated and driven to bring the case to the ICJ as it did, and the importance of that. I will give a little bit of overview about where things stand in the case, and then speak about the provisional measures, as you mentioned, Dr. Wakar. First, as we all know, the case was filed in November of 2019. The court held a hearing on the Gambia's request for provisional measures in December of that year, 2019. And then in January 23rd, 2020, almost a year ago, is when the court issued its landmark and historic unanimous decision on provisional measures, which is a binding order on Myanmar. The obligations under that provisional measures order are binding on Myanmar, and they require Myanmar to take steps not to commit genocide, to take affirmative steps to prevent genocide from occurring, also to preserve the evidence of genocide, and to report back to the court on implementation of the measures that the court has imposed on Myanmar. And so these measures are extremely important because they are meant to preserve the rights of the parties during the case. And as we all know, cases before the International Court of Justice can take some time. And provisional measures are meant to ensure that during the length of the case, until the court can get to a decision on the merits, that the rights that are at issue in the case here, this means the rights of the Rohingya people not to be subjected to acts of genocide, that those rights are preserved. And so the court issued these orders in order to ensure that the Rohingya are not subjected to further acts of genocide, and that Myanmar is undertaking its obligation under the Genocide Convention to prevent genocide. The Genocide Convention itself sets forth 3 different obligations on member states. First is the obligation to prevent genocide. Second is the obligation to punish genocide when it occurs. And third is the obligation not to commit genocide. And so Gambia is arguing that Myanmar has failed in its obligations under the Genocide Convention by committing acts of genocide against the Rohingya, failing to prevent acts of genocide, and also failing to punish acts of genocide. And all of those obligations are at issue in the case that was filed before the ICJ, and ultimately will be decided by the court on the merits when it issues an ultimate judgment on the case. Just in terms of timeline, I think everyone who's following the case may be familiar with the fact that the Gambia filed its memorial in the case on October 23rd of last year, 2020. And the memorial is the brief, the pleading, which sets forth the Gambia's full case on the merits. So that is the pleading in which the Gambia provides all of the justifications, arguments, evidence that it is relying upon in order to show that acts of genocide indeed took place, and that those acts were undertaken with the requisite intent. The issue of intent is one of the key areas that this case will end up focusing on, whether there is sufficient evidence to prove that when Myanmar took the horrific actions against the Rohingya people, when Rohingya were murdered, when women and children were specifically targeted and killed, when people were killed while they were fleeing, when villages were burned down, when people were burned down while they were in their villages, all of these horrific acts that we are familiar with because of the courageous reporting by the victims, by Rohingya who survived this genocide, who were courageous enough to share their stories with journalists, with human rights reporters and defenders. We know that these facts occurred based on their testimony, based on the independent and authoritative reports of the United Nations and of human rights organizations. What the Gambia has done in its memorial is to present all of the evidence which shows that, which proves that not only did these acts occur, but these acts occurred with the intention to destroy the Rohingya group in whole or in part. And that was what was provided in the memorial itself. And Myanmar will have an opportunity to respond, to put its defense case on the record in what is called a counter memorial. And that is, it's their response to the Gambia's memorial. And that is due on July 23rd of this year, July 23rd, 2021. Now, these dates that I've mentioned, at least the due date for Myanmar's brief, it assumes that there are no preliminary objections filed. Under the ICJ rules, Myanmar, as the responding party, has the right to file what are called preliminary objections, which are essentially jurisdictional objections. They're objections to the court's jurisdiction over the case. And if these are filed, then the merits schedule is essentially suspended. It is postponed until the court can rule on those jurisdictional objections. We've been informed that Myanmar has in fact filed preliminary objections, which means that they are objecting to the jurisdiction of the court. During the provisional measures hearing, we heard some jurisdictional objections by Myanmar as part of that hearing, and Gambia responded to those objections, and the court rejected those objections again unanimously by a 17-0 verdict. So we will see exactly what specific objections Myanmar is making to jurisdiction, and the Gambia will, of course, respond appropriately. And the court may decide to hold a hearing on these objections, and ultimately will have to rule on the objections before the merits schedule will resume. And once the merit schedule resumes, then Myanmar will still have the requisite time to file its counter memorial. So the schedule is going to be pushed back a little bit because of the pending filing of the preliminary objections. But ultimately, we are confident, the Gambia is confident that there will be a full hearing on the merits, and the court will declare and adjudge that acts of genocide occurred against the Rohingya, and will ultimately order restitution for the victims. And that is the goal behind the Gambia's effort to achieve justice for the victims. I'll stop there so that we have sufficient time for questions, which may be an easier way of going about discussing the case. Thank you.
Thank you, Mr. Arslan Suleiman. Thank you for your wide coverage. One thing really significant during that hearing at ICJ, with you, we're sitting there and we're looking at the judges, I think 17, 19 judges. And one of the judges are ad hoc judge from Myanmar side, correct? And there are so many significant things, but one of the significant thing was that judge from Myanmar side also voted along with other judges. So that's significant. That shows the clear cut of the solidness of the case. That's the legitimacy of the case and how solid the case is. And that's very significant, I believe. Thank you, Mr. Suleiman. With that, I'm going to go to next speaker, Dr. Hassan Abedin. There's a lot I can talk about Dr. Hassan Abedin. I've worked with Dr. Abedin for 10 years in OIC. So, but again, I will make a short introduction due to time constraint. Dr. Hassan Abedin, Dr. Hassan Ahmad Abedin actually, was formerly the director of the Department of Communications, Department of Muslim Minority and Communities in OIC. As part of his work at the organization, he closely followed the situation of Muslims as minority department, Muslims in many parts of the world, including Southern Philippines, Thailand, and Rohingya of Myanmar, and helped to develop political support for the ICJ case within the OIC Secretariat. We will have a question and answer section. Dr. Abedin, there are a lot of questions for him as well. So there will be more coverage about his role in OIC and working with him, Arakan Rohingya Union, working with him also. So basically his background is he has a PhD degree, doctorate degree in international relations from the University of London, and has an interest in mediation, peace building, and community empowerment. So with that, the floor is yours, Dr. Hassan Abedin.
Bismillah ar-Rahman ar-Rahim. Thank you, Dr. Waqar, for that introduction. It's very generous of you to say all those things. And thank you also to Arsalan. It's great to have him on this panel. And indeed, this distinguished group that we've heard from so far has really outlined how important this case has been, not only for the Rohingya, but for the international community. So I'd like to thank Ambassador Fatima for her contributions, and of course for the Solicitor General as well. Now, how to cover 10 years of work? I think to begin with, the OIC as an international political organization has tried to do three things essentially for the Rohingya people, and that is to raise the political awareness among not only member states, but also the international community of the suffering and the plight of the Rohingya community. And this is really a story of, as Arsalan said very well, of the courage of the common Rohingya living in Myanmar and those in the refugee camps in Bangladesh. The courage to come forward and to raise their voices. And of course, the great courage of the people of Bangladesh that welcomed them with open arms. And we have to acknowledge the great debt that the people and the government of Bangladesh are owed by the international community for receiving an almost incalculable number of refugees over 4 decades, hosting them, providing them with shelter, safety, and security, when even among their own people, they have faced a number of challenges, both economically and so on. And so we have to recognize that first before going forward. But much of the world outside was unaware of this long suffering plight of the Rohingya. And that's where the OIC in 2012, when the first modern period of incidences of violence, and again, these were driven by often Islamophobic tropes, fake news that we now the term which we so commonly throw about now, really started, in this case, the entire conflict that we're talking about. Social media was used by extremists, by right-wing communities that sought to cleanse their land, in their view, of the foreigner, of the outsider, who they tried to paint a picture of the other. And we have seen that so destructively used in the modern world. But this is a story which has affected the Rohingya community intimately for the past 10 years and going even further. But it was a fake story about Rohingya boys that had attacked a Buddhist woman that led to mass riots on the streets of Myanmar, and perpetrated this image of the dangerous and vile and predatory Rohingya that were parasites on the Myanmar society, when in fact, for generations, the Rohingya had lived as part of Myanmar society in harmony and symbiosis. In fact, the stories that we heard when we visited were of the Rohingya merchants selling the fish that were caught by the Buddhist fishermen. They would go out in the morning, catch their fish, come back to the market, and they would be sold by the Rohingya merchants, and a tidy profit would go to the fishermen for their efforts. There was a symbiotic relationship. And that relationship was something that had been forgotten by extremists who wished to poison the wells of that harmony by talking about them as being foreigners, being Bengali, being outside. And unfortunately, their success was partly due to the political situation at the time, where the country was going through a transition from military dictatorship to democracy. And in those times, political movements were used to get votes by different forces and by different entities, and it was politicized. The identity politics of the Rohingya were used by different groups to gain support for those military officers that wished to take off their uniforms and create political movements that would guarantee votes. So ironically, it was the famous democracy icon that the world celebrated, Aung San Suu Kyi, who had initially allowed and welcomed the Rohingya into that party. And many Rohingya actually participated in the NLD movement and were members and actively supported the move of the country to democracy. And how ironic, a decade later, when that icon refused to even acknowledge the term. And this was something that the OIC had worked politically to ensure was not forgotten, that the Rohingya have an identity, that this is their name, and they should be called by this, because the government of Myanmar denied their very existence. So politically, the OIC was determined to ensure that that was not the case. And it worked to establish in 2012 the OIC contact group on the Muslim minority in Myanmar. This contact group was the political vehicle by which the organization would raise awareness not only among its member states, but in the United Nations system, both in New York and Geneva, to ensure that resolutions were adopted by the international community that put pressure on Myanmar to accept the Rohingya as their citizens and to recognize their human rights. And this is where international cooperation became key. It was a time when the United States, Britain, and the EU worked together with the organization to support language that would be universally accepted. And I think this was a testimony to the work of Arsalan and his predecessor, Rashad Hussain, in the United States State Department, and those in the British Foreign and Commonwealth Office and the EU Secretariat in Brussels. It was because of the work of dedicated civil servants and diplomats who understood the need to put language that would put pressure on Myanmar. And we also had the support of the highest voices in the land, where at that time, President Barack Obama was engaging with Myanmar. And it was Secretary of State John Kerry who was coordinating with the OIC Secretary General on language that President Obama would use in his visit to Myanmar. And even we went to the extent where the text of the speech of the president was being discussed by diplomats, and the OIC was asked if we had any inputs that would help in the formulation of a positive message during that visit. And one thing that the organization said is important is that the president should say the word Rohingya, because this must be unequivocally accepted by the government of Myanmar, that the Rohingya exist and this is their identity and this is the rights that they have. So the contact group was the vehicle by which these various international meetings would be addressed, because the contact group would hold its sessions, brief the members about the situation on the ground. And this is where the OIC engaged with organizations like the Arakan Rohingya Union. Dr. Waqar-Uddin is a veteran of these meetings because he used to regularly be invited by the member states and the Secretary General to brief the group about the situation on the ground. Through his network of contacts, he was able to provide valuable information, insight, which enabled the organization to work with the EU and the United States on those very important resolutions, one of which Ambassador Fatima mentioned in her presentation. The language that in these UN resolutions is a very complicated and convoluted process. It's often subject to long negotiations for many hours as words are debated and paragraphs are endlessly revised. And it takes a great deal of effort and diplomatic skill to come to agreements. And this is where the support of Dr. Waqar-Uddin was essential in getting those consensus resolutions adopted. The second area the OIC has been involved in is humanitarian support for the Rohingya refugees, both inside Myanmar and in the refugee camps in Bangladesh. Now, one of the things that is often less appreciated is the fact that the organization's member states have been on the ground and creating medical facilities, hosting food distribution banks, and these are the ways in which the organization has been, through its member states, been able to assist those communities. One of the things that the organization tried to do back in 2012 was to have its own office established, and the government agreed initially to do so, but subsequently they went back on their word and did not allow the organization to establish its own humanitarian office, but rather said that they should continue to distribute food and medicine through the various countries that were present already. And that has continued. And we could go through a whole list of those countries that have provided such support. But the third area, which I've already alluded to, has been the civil society empowerment. And I think this is where the organization has worked to ensure that the Rohingya voices are heard in the international community. The OIC has supported both within its member states and in the international community the voice of the Rohingya to be amplified. It should be heard at parliaments, in congresses, at UN meetings. It's essential that we have the authentic voice of the people, so that the world understands that the Rohingya are a community that deserve to be recognized. And this ICJ case is one of those vehicles by which we have achieved that, I think, in the most spectacular way. And this legal case is really the outcome of the years of the OIC trying to use these political, humanitarian, and civil society mechanisms to put pressure on the government of Myanmar to restore the rights of the Rohingya. And finally, we found last year the ultimate judgment in the ICJ of this very reality. And it starts again with, it's a story of individuals who found this plight of the community very personally affecting, and it was really Ambassador or Minister Tambadou who happened to be attending the OIC ministerial meeting in Dhaka, Bangladesh in 2018, representing the Gambia, and it happened to be that year that the foreign minister was traveling with the president and was not able to attend. And so the Minister of Justice was standing in his place. And Minister Tambadou's experience and wise counsel is really one of the main reasons why the process began, because of his understanding of the international legal system, and his advice to the OIC was critical in moving this process forward. And subsequently, the legal team that was assembled, the fact that we had Arsalan on board with his knowledge of the OIC and of the international legal system, those unique individuals with their experience and with their dedication and with their knowledge of the situation all helped to bring the case to where it is today. There's much more that I could say, but I think I'll stop there and allow for questions and discussion. But thank you very much for the opportunity to share a little bit of the efforts of the organization. And of course, there's much more to be done. But thank you, Dr. Waqar, for this opportunity.
Well, thank you very much, Dr. Hassan. I think what you have just said is just tip of the iceberg. Working with you for 10 years, I see that you have not said much in the greater context. I think books has to be written on this, thinking about resolution after resolution, United Nations Human Rights Council, General Assembly, Security Council, OIC Council of Foreign Ministers, Ministerial Contact Group, on and on and on. The amount of work went in just from the OIC point of view. I think not one volume of book will be enough. You know, we are brainstorming for 2 years before we went to ICJ. We had working with you on the political side, political avenue, and then thinking about the legal issue, and then brainstorming this for 2 years before we went to Arsalan, before we went to, before meeting with Gambia, His Excellency Tambadou and others. It's just information. It's an ocean of information activity. Thank you very much for your heroic work at OIC. You were instrumental in this. That's why we're here today, because of your efforts. Thank you, thank you. Rohingya people will never forget your efforts you put in this.
It's really, Dr. Waqar, you're very kind, and it's really, I thank you and for the Rohingya people that may be listening in, that it is your courage that we salute and celebrate. And it's because of you that we're here, and we'll continue to support you and see that justice is done. This is something that is irrevocable and irrefutable, that the United Nations has called this the situation, the world's largest discriminated minority, and that is the fact on the ground. So there's no fake news here. It's all true. That the experience of your people, of the Rohingya, has to be acknowledged by the Myanmar government. And one of the things that I find so ironic, and I'll just give us a story, that when we visited Myanmar in 2013 as the OIC delegation with ministers from 7 different countries, the Minister of Borders and Immigration of Myanmar said to us that, Your Excellencies, we know that all of the Rohingya are our people. We have a record of every village, in every town, and in every household. We know how many males, female, how many children, how many cattle, how many chickens, exactly how many animals are in every household. So we said, well, if this is the case, then what's the problem? He said, well, we have a political transition to democracy, so we have to satisfy our other citizens that these are not foreigners, and we have to verify their cards. And it was, the story that we've heard many times before about verification. And in fact, this is really something that the authorities know full well, that the Rohingya people are part and parcel of the community. When you have more than 100 nationalities that are accepted, what is the issue with just with one more? And so there is a long story to be told about that, but there's certainly no end of our energy and commitment and determination to see this through.
Yes, absolutely. Very quickly, absolutely. What you say is correct. I was born in Rakhine State. I grew up in Rakhine State. I went to college. I went to school. And thinking back when I'm a childhood, we have never thought this will come to this stage. At this point, it is disheartening to think that they know. Now they know we are people of Arakan. We are the indigenous people of Arakan. These are just pathological lies. Now they are saying these are thus making up stories about Rohingya. So anyway, we'll have more questions answer session. We'll have more discussion on that. So now I'm going to move to, thank you, Dr. Hassan Abedin. Now I'm going to move to our next speaker, Dr. Gregory Stanton. I knew Dr. Gregory Stanton for a long time in Washington, and just has a lot of credentials Dr. Stanton has. Just briefly, again, due to the time constraint, Dr. Stanton is the founding president of Genocide Watch in Washington, the founder of Cambodian Genocide Project, the founder of Alliance Against Genocide. He was the president of International Association of Genocide Scholars. While in the US State Department, he drafted the UN Security Council resolution that created the International Criminal Tribunal for Rwanda in Africa. He was a driving force in creation of extraordinary chambers in the courts of Cambodia, the Khmer Rouge Tribunal known as, for which he drafted internal rules of procedure. He was the James Farmer Professor in Human Rights at the University of Maryland, University of Mary, Washington, and Research Professor of Genocide Studies and Prevention at George Mason University. Dr. Stanton, you and I had several conversations before about the ICJ case. I recall you made some points professionally about Professor Shabazz arguing at the ICJ court in The Hague, that Myanmar did not commit genocide against its Rohingya population. His argument rested on two ICJ cases, Bosnia versus Serbia and Croatia versus Serbia, as you indicated before. Could you give your perspective to the audience, as in our conversation before, on this ICJ case with regard to Bosnia and Croatia and Serbia, as well as your insight to what Professor Shabazz was arguing? The floor is yours, Dr. Stanton.
Thank you, Dr. Udine. It is a great honor to be on this panel with this distinguished group of people. I want to also underline something that Hassan and that Arsalan Suleiman indicated, and that is the personal aspect of involvement in this cause, because this is a cause. This is a case that represents the future of the human race. You know, when people go and actually meet the victims of a genocide, as both Arsalan Suleiman and Abubakar Tambadou did, who went to the camps, and as others here have gone to the camps and seen and talked with the Rohingya, they're deeply affected. It has a profound impact on people's will, on their will to pursue justice. And so that is why I think it is so important that we win this case. I just want to thank you and all of the people on this panel for your personal commitment to this case and to the future of the Rohingya people. And let me then comment, as Professor Udine has asked me to, on Professor Shabazz's argument in the case in the International Court of Justice. I have had a long-standing dispute with Professor Chavez about the meaning of intent in the Genocide Convention. In his treatise, which was published before both the Bosnia decision and the Croatia decision by the International Court of Justice, Chavez claims that genocide is completely different than what he calls ethnic cleansing. In other words, that they have different intents. In his treatise, which had a deep impact on the ICJ in both the Bosnia and the Croatia cases, he says, and I'm quoting, he says, they have ethnic cleansing and genocide have two quite different specific intents. One is intended to displace a population, the other to destroy it. The issue is one of intent, and it is logically inconceivable that the two agendas coexist. When he wrote those in his first edition, I immediately wrote to him and I said, Bill, you're wrong. Bill, by the way, followed me as the president of the International Association of Genocide Scholars. I said, Bill, you're wrong. You know, any prosecutor can tell you that the same act can have several intents. And any prosecutor can tell you that you can charge a person with two crimes for the same act. In this case, of course, forced displacement, which is in general the meaning that people attach to the word ethnic cleansing, and I'll talk further about that, does have one intent, which is to expel a population. And genocide has the other intent, which is to destroy a population, but they are not mutually exclusive at all. In fact, genocidal massacres may be used to terrorize a population into leaving. In other words, into forcibly being deported. And that is exactly what's happened in a lot of genocides. It's not just here with the Myanmar's genocide against the Rohingya. It's also, of course, what was done in Darfur. It's what was done in the Holocaust. It's what was done in many other genocides in which the intent of forced displacement was accompanied by, not opposed by, the intent to destroy the group. And Bill apparently didn't get it, because in his second edition of his book, he kept that same formulation in, saying that these were logically inconceivable that they would coexist. Well, he's wrong. And unfortunately, his error was reflected in the reasoning of the two International Court of Justice cases that are very important in determining the outcome of this case of Gambia versus Myanmar. In the Bosnia case, the court held, the International Court of Justice held, that although there had been evidence of crimes against humanity, they could not find the specific intent necessary to prove the crime of genocide against Serbia. And the court's reasoning, and here I am quoting from those decisions, the court's reasoning was that if there was any other possible intent for the acts that were being charged by Bosnia and then again by Croatia, then it couldn't be genocide. In other words, they adopted Chavez's what I call singularity of intent theory of intentionality for genocide. I believe that theory is wrong. It's not only wrong for genocide, think about it. It's wrong for any part of criminal law. If you had a singularity of intent requirement, you would say, for example, if somebody picked up a gun, pulled the trigger, and killed somebody, that you couldn't convict them of murder if they also had another intent, namely to rob the person, you know, to to have revenge against the person because he was sleeping with somebody's wife, you know, that kind of thing. In other words, if there was intent, they not only confused intent in this case with motive, which is a very big, a very different concept. In other words, motives about why do people commit a crime. Intent is what is included in the act of the crime. And in other words, Chavez has never been a prosecutor. He doesn't understand that these crimes can be coterminous. In other words, that they could coexist. And in fact, that is what has happened with the Rohingya. The deportation is one of the intents. So also is genocide. The Myanmar government intended to commit genocide. So one way in which the plaintiffs in the Gambia versus Myanmar case can argue is that in fact the court was wrong in its decisions in Bosnia versus Serbia and Croatia versus Serbia, that it is not proper to say that if any other intent can be discovered, then it can't be genocide. In other words, the singularity of intent theory is wrong. That's one way to argue. And I believe actually that it is, it needs to be said. I think that the court should overrule those decisions. One of the problems here is this whole term of ethnic cleansing. Ethnic cleansing has no legal meaning. It is not outlawed by any treaty. It's legal. Now, of course, we know what ethnic cleansing really means. It was invented by Slobodan Milosevic as a term as a euphemism to cover up genocide and forced displacement. But what has happened with the term, and Slobodan Milosevic intended this, is it is a way to deny genocide. It's a term of denial. And whenever you hear the word ethnic cleansing, you are hearing a denial of genocide, because ethnic cleansing has no legal meaning. You can't prosecute anybody for it. And in fact, it is a term that should be replaced by the legally prosecutable terms: forced deportation, that's a crime against humanity, or genocide, or both. And that is the case here with the Rohingya. In fact, I believe that the term ethnic cleansing should be expunged from the legal lexicon. It is incredible that it has actually taken hold. And every time you hear that term used, you know that someone is trying to deny genocide. And the UN and diplomats and other people who want to not use the word genocide very frequently use that term. So if we can't get the court to overrule its prior decisions in Bosnia and Croatia, how can we argue in this case in the ICJ? Well, lawyers know that one of the ways to get around a previous decision, and by the way, in this case, the ICJ is not bound by precedent. In other words, it can make a separate decision here. It doesn't have to follow its previous decisions in Bosnia and Croatia. Nevertheless, the ICJ is always reluctant to overrule its previous cases, as are most courts. The other way that you can get around this is what lawyers call distinguishing the case in the Gambia versus Myanmar case from those cases from Bosnia and from Croatia. How can we distinguish this case? First of all, in Croatia, the court, the ICJ argued, and I'm quoting, "The number of victims alleged by Croatia is small in relation to the size of the targeted part of the group." Well, the attack on the Rohingya was not small at all. In fact, Rohingya victims numbered at least half of the Rohingya population. 30,000 Rohingya were massacred. 700,000 Rohingya were deported. In fact, before that, another several hundred thousand. Mass rape of all Rohingya women was Myanmar Army policy. That's one distinction. Secondly, there is no minimum number of deaths necessary to prove genocidal intent. Conditions of life deliberately imposed to destroy a group is sufficient. And that's what we have here. Myanmar destroyed 434 Rohingya villages, over half of the villages, and destroyed all Rohingya food sources. That is imposing conditions of life deliberately intended to destroy the group. Thirdly, hate speech on Facebook created a culture of genocide in Myanmar. Facebook didn't even exist during the Bosnian and the Croatian genocides. We have here, in other words, a very different context in which this genocide occurred. I, by the way, believe that Facebook should be sued for incitement to genocide because it published those incitements. It can't be done in the United States because we have immunity under a strange law called the Communications Decency Act, Section 230. But there are many other countries where such immunity does not exist. And I'd like to see Facebook sued for billions of dollars for what it did. I'd like to see that in Myanmar, in Bangladesh, in Malaysia, and other places. Fourthly, the policy was the result of a decades-long ethnic and religious discrimination against Rohingya by the state in Myanmar. That is also a distinction from the Bosnia and the Croatia cases, where the discrimination only began really in 1992. In other words, just a few years before the actual acts of genocide. And finally, Myanmar's genocide against the Rohingya was perpetrated directly by the Myanmar army in both Bosnia and in Croatia. Serb militias, not the Serbian army, committed the crimes. So we have, I think, very solid ways to distinguish these previous cases of Bosnia and Croatia. I think it's very important that the fully Hogue legal team incorporate some of these ideas into their reply brief to Myanmar's memorial, and that we win this case.
I think Dr. Stanton has concluded your remark.
Yes, I have. Yeah.
Okay, thank you very much. Thank you. So we conclude the presentation in this session, and now the question and answer session. Of course, these questions were pre-populated before this meeting, and a lot of questions are already answered. For example, Bangladesh Ambassador, Her Excellency Rabah Fatima, and also Dr. Hassan has already covered quite a bit to answer the question, but we still have some that questions came from sources. So I would like to go to His Excellency Solicitor General Hussein Thamassi, if I may. But thank you again, I want to thank His Excellency Thamassi for filling in for the Honorable Minister Jallo. I believe he is still in the meeting with the president. I was told this morning over the phone that he will join in as soon as his meeting is over with the president. So I don't see him here logged in, so maybe he's still there in the meeting. So Your Excellency, if you are available, first question was about Maldives. There were reports that Maldives has announced that it will join the Gambia in the ICJ case on Rohingya. Can you tell the audience a little bit more about the status of Maldives, if you know about working with Maldives, if that information is publicly available. Your Excellency. I think we have a connection issue, I guess. Your Excellency Tamasi?
Yeah. Hello, Your Excellency, can you hear me, please?
Yes, I can hear you. You're clear. About the question, do you want me to repeat the question?
Yes.
The question was that...
can you please repeat the question?
Yes, yes, I am. Can you hear me? Can you hear me? Your Excellency, can you hear me?
I can't hear you. Can you please repeat the question for me?
Okay, now they're repeating the question. Hopefully you will hear me this time. I think it's a connection issue. Maldives joining.
Yes, I can.
Maldives joining Gambia. Reports of that in the report that Maldives will join Gambia in the ICJ case on Rohingya genocide. Can you give the audience a little a status about what is the status of Maldives working with your team?
Okay, thank you, Your Excellency. I'm aware that Maldives has made an application or approach our mission in New York to join the case alongside Gambia. I am not sure what decision has been reached at this stage, but I believe the matter was considered and an appropriate response was provided. But I cannot tell you precisely what was the response that was given. But I know that there could be two ways of joining the case, and I think the thinking at that time that a decision was made concerning Mali, which I'm not precisely sure it has been communicated to them, was premised on the fact that Maldives is a member of the OIC. And since OIC as a group is supporting the case, one should not isolate Maldives from the group that is supporting the case. But I think there was a thinking to that effect, but what was precisely communicated at this stage, I don't know, but maybe I'll find out and I could let Your Excellency know in due course. I wish the Honorable Minister were here, or maybe our lawyers, if Arsalan is there, perhaps he may be able to be of some assistance. Thank you.
Thank you, Your Excellency. Thank you very much. That question will go to Arsalan. He can also, Arsalan, you may also address that question I asked about the final status about Maldives joining Gambia. We can answer that along with this question here. So basically, public is very interested. I know there's a lot of confidentiality, a lot of court procedures, court policy, what is public information, what is non-public information. So I've been receiving a lot of calls about that. Even I do not know. Sometimes you and I talk about these things on the phone, as you remember. But we cannot discuss a lot of things. Confidentiality is there. So still within the context, can you give the audience, elaborate a little bit about the current implementation, Myanmar government implementation of provisional measures, provisional measures ordered to Myanmar by the court. How much you can talk about that? How much Myanmar has done? I don't know. I know we cannot go specifics on these reports, but and on a nutshell, what would you like to say?
Sure. Thank you, Dr. Waqar. Just to add to Solicitor General Tomasi's answer, I think everyone is aware that publicly, I believe some representatives of the Maldives indicated that they wanted to join the case in some way. And I think there has not been any public update as to that status. They may still have that intention. I'm not sure whether they've decided on whether or how to move forward with it. So as of now, There is really no update on that specifically, but it is worth noting that Canada and the Netherlands have also indicated publicly their intention to intervene in the case as members of the Genocide Convention, and to opine to the court on specific elements of interpretation of the convention that they find particularly of interest to them. And so we'll see how that ends up playing out. We don't know anything other than what was made public in their statements, which indicated that intention. In terms of the implementation reports that you mentioned, Dr. Waqar, so as you mentioned, the court has kept the implementation reports confidential. They have not released them publicly and have instructed the parties to maintain their confidentiality. So I know that many people would like to see them and are interested in see them, and I've heard many persuasive arguments as to why they should be made public. But for now, we're unable to comment specifically about the contents of those reports. However, Myanmar has been has publicly made certain announcements and pronouncements about that relate to the Genocide Convention. As you recall, very soon after, within the I guess 2 or 3 months after the court's provisional measures ruling in January, Myanmar had issued some proclamations that relate to informing its various agencies and departments and armed forces and others about the Genocide Convention. They also had a directive issued that related to hate speech, which is of course intimately tied into genocide and the process of genocide, including the dehumanization and the spreading of that hate speech, which Dr. Stanton rightfully remarked on and called out in his remarks. So they've issued some of these public proclamations, which I believe from their perspective is part of their effort to comply with the provisional measures. However, the reality on the ground unfortunately hasn't changed. And the same way in which in 2019, the UN fact-finding mission said that the indicia of genocidal intent remains and the risk of genocide remains, in fact, has maybe even increased. I don't think those facts have really changed very much. And reporting from various human rights organizations consistently shows that, unfortunately, the Rohingya who remain in Myanmar remain in a very precarious situation, remain subjected to violence, and I don't think that enough has been done to ameliorate those conditions, sufficient to say that they have abided by the court's orders. So I think I'll leave it at that. I think there are a number of NGOs and others who have issued reports around the time of the implementation reports in May and November. And I think many of those reports raise very serious facts that relate to the lack of implementation.
I have a question, if you don't mind. I have a question for Arsalan because, and by the way, I think you're a hero, Arsalan. I really do. I am really grateful for your work on this. I wanted to know, because in reading the rules of the ICJ, I don't see anything in the rules that would require the ICJ to keep these reports from Myanmar confidential. And I'm wondering if the Gambia could petition the ICJ to release the periodic reports from Myanmar.
Well, thank you for that, Dr. Stanton. I think you are actually the hero for so many of us, and we all know and we both agree that on this situation, the real heroes are the Rohingya who survived this horrific genocide and have had the courage to speak out, and for whom we're all undertaking these efforts. But I appreciate that. The court, I think, is within its own right to state that whether they are going to maintain the confidentiality of the document up until a certain point. the practice for the court with pleadings, for example, is that they don't make the pleadings public until the hearing, the public hearing on the merits begins, for example. So Gambia's memorial, which was filed in October, won't be made public until the actual oral hearing on the merits takes place. And it's not clear to us whether the court plans to make the implementation reports available at a certain point, or whether they are going to, consider that or reconsider that, or in some ways think about that. But from our understanding, given the rationale that I think the court has for not releasing pleadings early, which might relate to the ability of other actors to opine on a pleading or to somehow provide their own analysis, which could then help a party opposed, right? It might upset the balance or the idea of equality of arms. And so for that reason, I think the court has held off on making them public, and maybe they're waiting till perhaps the oral hearing on the merits, which might be the right time from their perspective in terms of these considerations to make it public. But yeah, I think that's sort of been perhaps, and there's no indication that I have specifically as to this being their thinking, but that's sort of my own understanding of where their thinking might be.
Thank you, Dr. Stanton, Mr. Suleiman. Now the question is for Dr. Hassan Abedin. Dr. Hassan, working with you for 10 years on Rohingya issues, side by side, we are aware of a lot of things. But I have a question for you I'm asking just for the audience, because what I know working with you, audience may not know all what went on inside OIC about Rohingya issue. Except for the General Assembly and Human Rights Council other things. First thing is that getting the 57 member states. Again, I knew this working with you, but for the audience, getting the 57 member states on board on this ICJ case, in support of ICJ case, and they're reaching out to Gambia. That was a monumental task. I remember 2 years back how we established how much work into that. But public is very, very curious about how this could have happened, because this is the kind of case, unique case, right? Gambia, 1,000 miles away from Myanmar. A country of Gambia is fighting for an ethnic minority of another country. Rohingya are not even nationals of Gambia. They are Rohingya, are ethnic minority of Myanmar. And then Gambia from thousands of miles away fighting for that. So it's really very interesting. I'm not aware of any historic case in this kind of case. The first time that we have seen, God bless our son Suleiman and Holy folks. And so to the point, can you give us a walkthrough, the audience, that what went into these efforts?
Well, thank you, Dr. Waqar. Of course, there's a lot to be said about the political process behind getting to where we are today in the legal process with the ICJ. And yes, you're right. It took, over 2 years from the point that the idea of presenting a legal case was first agreed. And I think this goes back to 2018, when it so happened that in January of that year, there was a delegation from the OIC Independent Permanent Human Rights Commission that went to Cox's Bazar. I was in that delegation along with legal experts from the OIC member states who were going to visit Cox's Bazar to interview Rohingya refugees, to take their statements, to get depositions that would recognize and register their plight and their experiences. And as Professor Stanton had rightly pointed out, that it is because of those personal experiences that each one of us have had in various ways and capacities that we remain committed to this cause. You can't help but not be. And that was a time of visiting the refugees in Cox's Bazar. It wasn't the first time, but it was a poignant moment because it was after the 2017 crisis of August 2017, where literally within a couple of weeks, over several 100,000 Rohingya were forced to flee for their lives in terror, and that was something that we hadn't seen in the previous 8 years in working on this through diplomatic channels, or even working at the highest levels. We hadn't seen that level of violence in such a huge way. And I think that it was visiting the border with the Bangladesh border force, and the colonel in charge took us to the very edge of the Bangladesh-Myanmar border area, where there was a no man's land in between. And he described the morning of August 25th, 2017 in such graphic and moving ways that we were all captivated as he described the start of that morning, which was like every other, very quiet and peaceful. It's a very lush green vision, as you know. Trees swaying in the breeze, tall grass, nothing that would indicate anything untoward. And he described the sound of screaming that pervaded the atmosphere, and the vision of hundreds, thousands of women, largely, and children just cascading down the hillside, stumbling and falling. And he couldn't understand what was happening. And he said behind them, there were mortar explosions that were going off. And he said, as a military officer, he couldn't comprehend how civilians would be caught up in the middle of what seemed to be a military operation. And within moments, his soldiers were reporting that dozens and dozens of women and children were arriving at the border posts, screaming and talking incoherently about what had happened. And he said that was the beginning of their understanding of the scale of the events, because within a few hours, that numbers that were on their borders were in the thousands. And he said it just was unbelievable. So those kind of frontline experiences were what really led us to understand how serious that August 2017 event was. And when we went to the camps, we heard graphic stories from the survivors of what had actually happened. And those were the stories that we reported to our member states, our Secretary General, and to the ministers of the countries that were represented. And it was 6 months later where the OIC was organizing the annual ministerial meeting in Dhaka. And part of our discussions with the foreign ministry at that time in January were that this issue needs to be raised at the highest levels of the organization. You have to have ministers themselves seeing is believing. If you are going to have the ministers of 57 countries here in the capital, they have to come down and talk to the refugees one by one and hear for themselves and see and visit this. And that's really the discussion that we had with the foreign ministry officials, was about how can we make this this ministerial meeting meaningful, not just for resolutions, but for changing minds and changing hearts of diplomats and politicians. And so it was the planning and working closely with our counterparts in the Bangladesh Foreign Ministry, who themselves were saying that we have been dealing with this for years, and we want the international community to see for themselves what is actually happening. And so that May, the OIC ministerial meeting was indeed brought down to Cox's Bazar to visit the camps in a very well-organized visit. And not only were they there, but also it so happened that the Canadian foreign minister and a large delegation of Canadian diplomats who were invited guests to the meeting also came and saw for themselves the situation on the ground. And that really changed the whole dynamic, because no longer could this be an abstract idea of refugees in camps, but these were real people. These were little girls. You know, the one thing that struck us was that everywhere you could see, there were these tent-like structures established, crowded on top of each other, and it was filled with girls between the age of 5 and 10, little children. You know, there were very few men, and women were there, but it just seemed like we were in a giant orphanage of a kind, and it just pulled at your heartstrings to see that. And indeed, that was the situation that Minister Abubakar Tambadou, who was representing the Gambia, saw when he visited with the rest of the delegation. And when we flew back to Dhaka for the official meeting, when everyone changed out of their muddy shoes and soiled trousers and dusty jackets and put on their ties and their clean white shirts and their blazers again to enter the diplomatic meeting, it seemed so surreal that we had just witnessed the most painful human suffering, and now we were going to sit down in a leather chair at a nice desk with a nice cup of tea and discuss this political issue in an abstract way again. And we said, no, we can't do that again. We have to take action. And this is where many of the ministers were moved to take action, but they didn't know exactly how much more we could do. And it was Minister Tambadou who said that the Gambia would like to propose a resolution on taking legal measures against the government of Myanmar for the suffering of the Rohingya. And that was the beginning. It was his expertise and experience in the tribunals, in the UN system, that he knew how to articulate the concerns of the organization and put it into a format that was actionable. Because he was not a diplomat, he was not a politician of, he was not from the foreign ministry. He was a lawyer, a scholar, a legal mind. So he immediately went to how the mechanisms of justice work and what we can do to bring justice to the cause, while others might have been thinking, what political pressure can we do? What sanctions, what political moves can we make? Can we raise it to another UN? Can we have a UN special session? Can we have a presidential statement? Can we bring it to the UN Human Rights Council again? Which was already happening and was part of the normal routine procedures that had always been taking place. And there were resolutions at the UN Third Committee in the General Assembly. There were resolutions that were adopted in Geneva at the Human Rights Council. And there was a talk of stronger wording and heavier sanctions, perhaps alluded to. But it was Tambadou who said, no, this is how we can do it through the legal mechanism. But of course, that was just the beginning, because what legal mechanism would we use? There could be, obviously those who are in the know would say ICJ, the International Court of Justice, or the ICC, the International Criminal Court. And that was, again, a process by which the political leaders needed to be guided to. And this is where we were fortunate to have Minister Tambadou at the leadership of that, but the expertise of Arsalan Suleiman, who came with the ideas of how to put that, to paper, because he had worked with the OIC as the special envoy of the US to the OIC. So he knew how OIC resolutions worked. He knew how member states were, how they would operate. And he was able to sort of provide the kind of connectivity for us. And that was an important period of cooperation between May 2018 and the following year, because the ministers agreed in Dhaka to establish an ad hoc committee. This was the committee of member states that would be essentially, there are 10 member states in that committee that took the responsibility to investigate which legal measures would be adopted. And the Gambia was selected as the chair of that committee, with Bangladesh as the co-chair, precisely because of the Gambia's own process of appreciating the importance of justice for all, because they had gone through their own political transformation in the previous year with a new government in office. And Minister Tambadou was able to provide that leadership from the Gambia to that committee. And we spent a year just looking at the various options and talking among the members of that committee, and we had a meeting in Banjul, the capital, 6 months later, in which we had a very serious discussion among the committee members, and where Arsalan briefed them on all of the various legal options. And the committee then discussed, okay, what can we take from this briefing? How can we move forward? And there were very heated discussions about what are the merits of going with the ICC and the demerits of that, or what were the merits of going with the ICJ. And that was really, he could go, Arsalan could perhaps talk in more detail about that, but those were some of the very intense discussions that I think, Dr. Waqar, you were alluding to, that we had to explain exactly how each of these various international mechanisms might play out. And some member states are not party to the Rome Statute and therefore wouldn't accept us going down the route of the ICC. There was a very strong push by the European Union that was supporting resolutions with the OIC and the United States that the preferred route was the ICC because it was targeted. You could target individual ministers, individual agents within Myanmar who would be liable for sanction. And there was a logic to that you could identify the military generals and put them to take them to court. But the downside of that is that the system as a whole is left without, to continue. And the ICJ in its sanctions will be focused on the entire government, and the whole system will be held to account rather than just one or two individuals who might be just denied their shopping trips to Beverly Hills or to New York City because they will be banned from travel, but the rest of the system would go on. So there are these various debates and discussions which had to take place, and it was really down to these individuals that I've mentioned and their experience and knowledge of law, of the political system, and of their personal commitment and conviction, which really led to where we are today.
Well, thank you very much, Dr. Hassan. Abedin, I know that's not enough. I know more that you could have covered that went on for 2 years. I was part of the conversation with you and in OIC, so this is good. There's a question came for Dr. Stanton. The question is that the recently the U.S. government have decided to announce something about genocide of Uyghur declared, and so the question was, what will it take? What will it take for U.S. government to do the same thing for Rohingya?
It will take a lot more courage by the legal department in the State Department. The legal department and the State Department has a number of people in it who, and I used to have to fight with them. They, as you know, denied that it was genocide in Rwanda for over 3 months. And by the way, Joan Donahue, who was one of the main people who resisted calling it genocide in Rwanda, is now a judge on the International Court of Justice. So we are up against denial. And in fact, the official phrase among the lawyers in the State Department is that this is ethnic cleansing. You know what I just said about ethnic cleansing being a term for denial. It will take political will. It will take people in the State Department who are more powerful than the legal advisors to direct the legal advisors to study this situation, I don't know, and in fact, lead them to a declaration that this is genocide. And we've, of course, been working on this for years. Genocide Watch declared it was genocide in 2012. but it just does take many people working together to influence policymakers in the US government, and particularly in the State Department. Let me just add one thing, since I can speak about this. And I just want to tell Dr. Hassan how inspiring it was to hear your story of how this came about. I was trained by Dr. Martin Luther King Jr. and the Southern Christian Leadership Conference in nonviolent resistance. And Dr. King always told us, personalize injustice, because injustice affects persons. And that is, in fact, what you were describing. That these persons who were all part of the OIC went to the camps and they talked to other persons. That also happened to me. It's why I got involved in this whole cause of trying to fight genocide, because I was a person who went to Cambodia after the Khmer Rouge had been overthrown. And I talked to so many persons who had lost their families. I just emphasize that because I believe we are working for a personal force. I think it's the same force that made the universe.
Yeah. Well, thank you so much for those comments. I mean, it is really those of us who are working now, we are really standing on the shoulders of giants like yourselves who have led the way. And it is because of the work that has been done by those before us that we're able to benefit from your wisdom and your counsel and your examples. So thank you, sir, for doing that, and we look forward to continuing to learn from you as we are learning always. It's a constant process. So thank you for your words.
Well, thank you very much, panelists. I think we are approaching 2 hours, although we have planned for an hour. So it is great opportunity to hear from you. I will really grateful to you for your time. So I think we need to think about concluding the session. But as a last item, I would like to ask the panelists, each one panelist, would like to make a conclusion remark, brief conclusion remark, starting with His Excellency Tamasi. I think you are muted. Your Excellency, you need to unmute.
Your Excellency, Dr. Udin.
Yes, I can hear you.
Am I clear now? Can you hear me, please? Yes, I just want to thank you for the invitation. Can you hear me, please?
Yes, clear, very clear. Yes.
Hello?
Yes.
Can you please hear me?
Yes.
We can hear you.
Yes, Dr. Udin, let me thank you for this invitation to share with you our thoughts on this day. I also want to thank all the panelists, and in particular, also want to extend our appreciation and profound thanks to our lawyers, represented by Mr. Arsalan here. But I just want to bring out something. It's important that there is more commitment to this case, the prosecution of this case. There are certain things that are lacking, and I do not want to perhaps mention it openly, but I think the member states that have committed themselves to this case and the member states that have requested Gambia to lead this case should actually meet their obligations to this case. I believe the lawyers are doing fantastic work, and we need to encourage them, and we also need to show them that we want them to continue to do this case for us. there is no point having to consider a change of counsel should our lawyers decide not to proceed this case because we are not meeting our obligations to them. I just want to throw in that it's important that the member states actually are seen to be committing resources in the prosecution of this case. This case actually needs resources for its successful prosecution. I just want to also use the opportunity that member states have also contributed to this case, and I want to thank those member states that have contributed immensely to this process. I think on that note, that was just a challenge I wanted to throw, which I believe is affecting the successful prosecution of this case. I know my minister would not speak like the way I am. I happen to be a technocrat. That's why I'm speaking this way. And I think this is actually causing a problem in this case. So we need more commitment from the member states, especially, I believe the representative from OIC would hear me loud and clear. But on that note, I just want to thank all of you and to thank you for your commitment and your concerns and in this crusade to ensure lasting justice for the Rohingya. I thank you all.
Thank you very much, Your Excellency Tamasi. And our second speaker, Her Excellency Rabab Fatima, had to go to a meeting to UN. So there's no opportunity for a remark, conclusion remark, but I do want to express our gratitude to Her Excellency for speaking earlier. We can summarize her speech, get the points from there, and as her conclusion remark. And grateful, we're very grateful to Bangladesh government and the Prime Minister Sheikh Hasina and the people of Bangladesh and government of Bangladesh and Bangladesh mission in UN at New York, all working to find a solution for Rohingya people. And so this in her remark, in context to her remark, that the Bangladesh has averted a major humanitarian disaster, saving nearly 10 million people, nearly over 750,000 people that crossed the border to take shelter, running for their lives. So again, I want to take the opportunity to thank the Bangladesh government and the people of Bangladesh. So that we do not have a conclusion statement from Her Excellency now. So I will go to Arsalan, Mr. Arsalan Suleiman, for your remark.
Well, thank you, Dr. Waqar, and thank you for the opportunity to present on the panel, and thank you to all my fellow panelists for their really excellent remarks. It's wonderful to see everyone, and thank you to everyone who's been tuning in, especially to the Rohingya around the world, in the camps, in Myanmar. The commitment of the Gambia to this case is unshakable. Our commitment is unshakable. We're going to see this case through no matter what. So rest assured that we're doing everything we can in our powers and our abilities to ensure that the best case is put forward, and that ultimately the goal that we all want, a successful resolution to this case, but more importantly, a successful resolution in order to allow Rohingya to return to their homes, to live a life of dignity and one in which their rights are respected. That's the ultimate goal here. And so we're all fighting towards that goal, and we'll continue to pursue that goal no matter what. Thank you.
Thank you very much, Dr. Aslan. But I want to go back to my thank to Bangladesh government when I said not 10 million, it's 1 million, over 1.2 million Rohingya refugees right now in Bangladesh. So they all need to be repatriated to their homeland. So the number is over 1.2 million. Thank you. And Dr. Hassan Abedin, do you have a conclusion remark? I would like to hear from you.
Thank you, Dr. Waqar, and thanks to all the other panelists for their remarks. It's been an honor to be part of this webinar. And of course, you have rightly thanked the government of Bangladesh and Her Excellency Sheikh Hasina and her entire diplomatic staff and the people of the country for their hospitality to welcome the Rohingya not just now, but for decades. And we support the Bangladeshi people in their efforts to be hospitable and look forward for this whole situation to be resolved in the near future. We pray that 2021 will bring hope for the Rohingya cause, not only the ICJ, but for them to be able to return to their homeland in safety and dignity and with their ensured livelihood. It's important to appreciate the efforts of all those that we have talked about in this call. I think that we look forward to the leaders in the OIC to maintain their commitment and pressure on the government of Myanmar, the member states that have taken this decision to support the case will continue to do so. And I believe that the OIC will, with its new Secretary General that will be joining this year, will also have renewed vigor and energy to be able to pursue this throughout the length of this case. And indeed, in the international community, we want to see Canada and the Netherlands take that active role and strengthen their commitment, as they have already indicated that they're willing to do so. And indeed, in the United States, with the arrival of a new administration, that shining city on a hill, we hope will beam once more again and shine their light of justice and freedom and equality for all. As Professor Stanton had mentioned rightly, the legacy of Dr. Martin Luther King lives on and is renewed and revitalized. And we hope that it will build back better relations for the world and will mean new hope for the Rohingya in their cause. And I'd like to just conclude with the remarks that Minister Tambadou gave so eloquently in his presentation to the International Criminal Court, that reminded us all that the only thing necessary for the triumph of evil is for good men to do nothing. And I think that that is a message that is meaningful to all of us, that we should take forward in 2021, is a continued commitment to do something, because that is the purpose of our being here. Thank you, Dr. Waqar, and thank all the panelists for their wonderful remarks and for their continued commitment. And God bless the Rohingya, and salamu alaikum to all of those in the camps that are listening in. And a reminder that you are stronger united than divided. I encourage all of you to stick together, to work together, to put aside your differences. We have seen the power of people coming together across the world, that unity creates change. And your future lies in your own hands. If you work together, support the ARU and Dr. Waqar and his efforts, that will give you the strength that you need in the international community, and it will allow us to see success for the Rohingya, not only this year, but in the years to come. Thank you very much, and wassalamu alaikum wa rahmatullah.
Thank you very much, Dr. Hassan Abedin. Absolutely, the unity is the key. Unity is the key. I would like to say this, despite some differences in views in the Rohingya community, like any other community in the world, you go to Philippines, you go to Kashmir, you go to Bosnia, Palestine, there's different views. But one thing, it was significant, was that how I've seen on my own eyes, how the ICJ case has brought Rohingya people together closer than ever. And I am very pleased to see the evolving, emerging cohesiveness and unity and cohesiveness in our community. And ICJ become a platform for this cohesiveness. Inshallah, we are looking forward to moving forward, and people are understanding better than before, and inshallah we'll be successful. With that, I would like to go to Dr. Stanton, if you like to give a conclusion remark, brief conclusion remark, that would be great.
Thank you. It's been a very big honor for me to be part of this wonderful panel. And thank you for organizing this, Dr. Udine. I'm just so grateful. I'm inspired by what we have heard today. I would just want to leave us with a thought that I think we need to also remember. The ICJ case is going to take years. And during that time, We cannot forget the people in the refugee camps. We must put all the pressure we can on our governments to help them, to make their lives easier, to give their lives all that their lives deserve, which is everything. And I just know that they will survive because I've seen it before. I saw it in Cambodia. I saw it in Rwanda. Those are countries that have come back to life. And I know that the Rohingya are not only alive, but they are a strong people and they will survive. The Rohingya deserve justice because justice is stronger than genocide. The Rohingya need our love because love is more powerful than evil. And with justice and love, I know that our hope can carry us through. And hope is the assurance that life will triumph over death. Thanks.
Thank you very much. All the panelists, yes, Dr. Stanton, you are absolutely correct. Rohingya people, we Rohingya people are strong. I would like to conclude this session with a word about Rohingya people. We are resilient. We are strong, we are resilient. We will survive this storm. We will ride out this storm, passing storm. Thank you very much, panelists. Thank you.
Thank you.
Goodbye, everyone. Assalamu alaikum.
Bye-bye.